SJC-13124, CP200 State LLC v. CIEE Inc.
Okay, Attorney Woodcock.
Jack Woodcock for Appellant CIEE. Madam Chief Justice, may it please the court. The agreed upon record in this case shows, contrary to the Superior Court's decision, that the parties long ago agreed to settle this action. The real question before this court is, as a matter of law and policy, the CIEE have to wait until a final judgment for its rights to be free from the very burdens of this litigation can be vindicated. Massachusetts law and Massachusetts policy in favor of supporting settlement agreements firmly support CIEE's right for an immediate appeal of the denial to enforce a settlement agreement. The common law doctrine of present execution applies here. That doctrine has two elements. The first element is easily satisfied, and that is whether the issue is collateral to the underlying nature of the suit. It cannot be seriously disputed that the issue is collateral. The underlying suit involved a dispute over a lease agreement. This is a dispute about a different contract, one that emanated from the first suit. If trial goes forward in this action, all evidence of settlement negotiations would be barred.
Before we lose track, what's the second one?
The second element?
Yep.
The second element is whether or not CIEE's rights can be finally vindicated on appeal from a final judgment. And that element is satisfied here as well. This court has determined that the protection from the very burden of litigation and trial is precisely the right to which it is a party asserts entitlement. The doctrine of present execution applies.
Is that in immunity cases? Are you citing that from immunity cases?
Yes, you're right, Your Honor. That is the state of Moulton. The doctrine of present execution, however, is not limited to immunity cases, and it is not limited to statutory actions. It's a common law doctrine. And the right implicated here by CIEE is simply the same right coming from a different source.
What about a res judicata case then?
Res judicata, as relied on by the appellee, is a completely different animal. Res judicata, first of all, is not a defense to liability. It is an affirmative defense which must be litigated. Secondly, res judicata is not collateral. It is bound up in the actual claims, and it's one of issue preclusion. So the court has to weigh whether or not the claims are the same. Thirdly, res judicata can be raised at multiple times, and should be raised throughout the course of a litigation on a motion to dismiss or motion for summary judgment after facts determine whether or not the claims are the same. That is not the case here with the motion to enforce the settlement agreement. That motion was denied, and there's no recourse until the end of a final judgment to raise that again.
I'm worried about some practical problems. So here's your case is a good example. Your clients, I can't remember, behind on the lease, right? They're way behind on their lease payments. They want the property. You guys get into these settlement discussions. I can't tell how far along they are. But now this could go on for years. So your client basically, if you bring in a premature settlement, suddenly now we have to wait for the appellate process to play out, which can take a couple of years. I'm just worried that we're going to turn all this kind of email correspondence. Lawyers often get close to deals, but don't actually get them. So comfort me that you're not creating basically a giant monkey wrench in the system here by allowing this to happen.
Yes, the dire prophecy
Well, it's
of
not so
opening
dire.
the floodgates to appeal is misplaced for a few reasons. One is the single justice notice. This is the first time this issue has come up in the entire application of common law doctrine. Two,
Well, but if we allow it, that's going to change the whole dynamic. Maybe this never been brought up because no one thought you could do this kind of stuff. But once we bless it, which is what you want us to do, aren't we going to get flooded with these?
well, again, past may be prologue here. A similar analogous situation happens with arbitration agreements. That's a contractual agreement to take the case outside the judicial process, and it has an immediate right to appeal both in federal courts and in Massachusetts.
There you
state
actually
courts.
have a contract to look at. We're going to be looking at, two lawyers' emails at night saying, we have a deal. If you do this, we might, that kind of stuff. That's different than a formal arbitration agreement, isn't it?
That may be so, Your Honor, but there are analogies here to these facts, and this court can always draw the appropriate opinion based on these facts. One, the record is undisputed and it's in black and white before the court. And two, this was done at the very outset of the litigation.
That doesn't
Whether-
comfort me as an answer, though, because that may well be true, but that's after we've had a full appeal and that has been briefed and we've had months and months and months of delay.
The appellate process does bring delay, Your Honor, but it also would bring certainty and perhaps resolution to this case in a way that would decrease the overall burden to the court system. If the appeal is granted and the settlement agreement is affirmed, this case goes away and it saves a jury trial, all the discovery and motions. This case has already generated 2 motions for preliminary relief, both for a
But
preliminary
counsel,
injunction.
which of those arguments that you make in favor of an immediate appeal do not apply to an appeal of res judicata?
Do not apply to a.
Yeah,
appeal
that
of res-
is all of those arguments that you're making, it seems to me, about the efficiency and how things could get resolved earlier rather than later, apply to the res judicata context. And yet we've said that is not subject to the doctrine of present execution. Can you distinguish this from that?
As I mentioned before, res judicata is not collateral. And so the appellate process would take up an issue that is not collateral. And
Well, why
fails
can't
under the-
you have a counterclaim to enforce the settlement or to cap the damages at 245,000?
Because the right CIEE bargained for was the right to be free from this very litigation.
For
And that right becomes-
$245,000, right?
That's correct, Your Honor.
So why is that right not preserved to end this at 245,000? You're saying the quintessential right in the settlement agreement is to avoid the litigation altogether. And I understand that. But you also resolve the case at 245,000. Why isn't that the more important right that you would be entitled to after trial?
There are 2 rights, Your Honor. One is the right to settle for $245,000. Money is fungible. Time is not. Time and burden and expense are in a business at this time that was navigating the swirl of the pandemic, placed upon burdens upon CIEE that are not redeemable upon final judgment. And so
But
rights
we
to
have to
money,
consider not just the time and burden on CIEE, but as Justice Kafker was saying, the time and burden on the appellate courts.
That is correct, Your Honor. There is, when an appeal goes up, there's always time and burden. And I think it's
Right. And so why not adopt the federal rule where the settlement agreement motion to dismiss would not be immediately appealable?
under 28 USC 1292, which is the federal rule for interlocutory rule. That's a statutory right and is statutorily restricted. And the Supreme Court determined based on the reading of that statute that a immediate appeal was not from a motion to enforce a settlement agreement.
Right.
This
And
court
so
has
why
far
don't we
more
interpret our
latitude here
common law consistent with the federal rule in that regard?
because the federal law is interpreting a federal statute. This court's jurisprudence over present execution brings a wholly different analysis than the 1292.
Yeah, I guess I'm wondering why. Why wouldn't we adopt the federal rule? It seems simple. It eases appellate burdens. And frankly, the argument that settlement agreements, the sole purpose and primary purpose is to avoid litigation is just not true. You bargained for $245,000 to settle this thing. In addition, you bargained to not go through with the litigation, but I don't know which one was primary.
Both rights are important and worthy of enforcement. And from the outset of this
Right, and
case,
so you can enforce the latter right, the $245,000 post-trial.
yes, Your Honor. As I said, money is fungible. Money is, if we win, we win. But that does not.
Well, I
take into
mean,
account-
litigation is a cost. That's fungible.
Yes, Your Honor. But there are many burdens, and this court only need look at the docket to look at the burdens attendant with litigation that CIEE has endured. One, it has faced a preliminary motion for attachment, and so it has a tangible, real world effect on CIEE's right. There's a building that has a $1.2 million attachment on it because the litigation went forward.
Well, I mean, you
That
could
would
say it was because the litigation went forward. I might say it's because you breached your agreement.
The parties reached a settlement agreement before the attachment hearing and before the issue of the attachment was ever raised.
How often do you think counsel for one party emails counsel for another party and say, hey, can we settle this for $500,000? And the other side says, yeah. That's a binding agreement in your mind?
If the material terms to a settlement agreement.
How do
are
I
agreed
know
to-
what's material?
How do you know what's material? The
Yeah, I
intent
mean,
of the parties.
in the emails you say, subject to the written agreement.
The other side said, provided that the terms are memorialized in a written agreement.
Right, and why isn't that material? Elements of confidentiality, I don't know, publicity on the various settlements, other terms that might be material. What law governs the settlement? Why are those not material terms?
They were never discussed.
Right.
And never contemplated.
Right.
When the parties said
Yeah, and
they
so-
had a deal.
To me, that seems like you didn't have a deal because all of these other terms that possibly could be material were not negotiated.
There are
So
many
they were
terms that-
subject to a further final written agreement.
Yes, Your Honor, there are many terms that may be material, but they're not material if the intent of the parties to be bound is not there. The material terms of the settlement were that they would settle the case and when CIE would pay. And those terms are agreed to, and under black letter contract law, that's an agreement. This court has firmly held for over 100 years that when the memorialization of those terms is done, that it does not affect the prior intent of the parties to be bound. As the appeals court.
Although those are not present execution cases, right? I read they're mostly appeals court cases that you're relying on, Fecto and these other cases where we say you don't really, these email cases, which is the ones that are making me the most nervous. The appeals court has had a couple of these cases where they say, well, the emails are enough. I'm I'm not sure I agree with those cases, but could we impose a higher standard for, present execution? I mean, I understand if you had a fully executed agreement, you got a real contract there that's got both parties' signatures and they say this is a final agreement. I can see there maybe it makes sense. It's this kind of mushy lawyer email stuff. It doesn't seem conducive to this. Can we draw a distinction there? Have any courts done that, saying, okay, we'll allow present execution on a fully executed contract as opposed to this kind of lawyer happy music to avoid going to court?
There are no cases of which I'm aware that discuss present execution in the formation of a contract issue. There's two.
I just find it's much, I see your points. If we have a fully executed contract that, clearly settled everything and then somebody's trying to back out of the deal. I have a lot more trouble because it seems to me to open the floodgates to allow present execution to apply in this kind of sort of fluid situation where you don't have it all written down. But again, no cases to guide us, nothing supporting that approach out there, I take it.
But Your Honor mentioned the appeals court cases, Basis Corp and Gorin. Those stem from an interpretation of this court's pronouncement in Rosenfeld, where the mere memorial of a written agreement does not affect the fact that the parties already reached agreement to the terms. The parties in this case said they had a deal, and the unequivocal record shows that there were no other material terms discussed or contemplated.
He's going to stand up and say, we didn't have a deal. And the Superior Court judge accepted that. We look at the documents anew, but it's not so crystal clear that there was a deal.
Your Honor, if I may respond to the Superior Court's pronouncement, the Superior Court found that the parties did not have a deal because whether or not the hearing was canceled was a counteroffer. It construed that as a counteroffer. The unequivocal record shows that was agreed to. That element was specifically agreed to. And so directly to the Superior Court's conclusion, there was the counteroffer, even construing it as such, was agreed to. The other side said, I will contact the court and take down tomorrow's hearing. So there was nothing that was not agreed to. The parties reached a settlement, and this court should enforce it, whether or not present execution applies.
Oh, counsel, I have just one more question. You had mentioned that you couldn't bring the enforcement of the settlement agreement issue in the present case without breaching, I think you said, confidentiality, why couldn't you have a counterclaim to enforce a settlement?
I believe I stated earlier that it's collateral because the evidence about the settlement agreement would never be presented by the jury.
And then my question is, why not?
Because under Rule 408, settlement discussions are barred.
Even if there's, in your mind, a settlement?
Yes.
Okay.
Okay, thank you. Attorney Luccio.
Good morning, Chief Justice Bud, and good morning to the rest of the court. Before I address the threshold issue, I would like to briefly note the common theme running through the three key emails in this case. Those emails are the hearing email, the proviso email, which introduces the execution of a settlement agreement, and the all bets are off email. The common thread to all of those emails is that the hearing going forward serves to reject the offer in the hearing email. That hearing went forward, the offer was rejected, and there is no deal here.
Well, I mean, if the hearing went forward and there was a deal, wasn't that just a breach?
That is true. If there was assuming there was a deal and the hearing went forward, that would be a breach. But here, the hearing going forward or not going forward is a condition precedent.
Well, that's what the judge said. So can you explain to me the difference between the condition precedent and the offer, the counter offer? Like how do we really know when something is a condition precedent versus a counter offer?
Well, you look at the language used.
Mhm.
You also look at the surrounding facts and circumstances. And in this instance, with the hearing email, I'd like to.
One on, that came at 3:40.
It's the one in which.
It ends with deal, right? Question mark.
I'm sorry. No, that I've been referring to that as the proviso email. So let
That's
me
the
do a
proviso.
better job of setting the table.
Okay.
What I refer to as the hearing email is the email from CIEE in which the parenthetical was used. This assumes that tomorrow's hearing does not go forward, or words to that extent.
Right, that came at 3:40.
Okay.
That's
And-
the one that the judge said was the counteroffer, right?
Exactly. And I would like to point out a matter of punctuation, which is an important matter. That email ends in a question mark. One does not accept an offer with a statement punctuated by a question mark. That is clearly, based on that punctuation alone, a counteroffer. It's also a counteroffer because it contains a new condition precedent. And we know that based on the language that was used in the email and the language that was not used.
So you're saying it's a counteroffer and it contains a condition precedent.
Exactly.
Okay. All right.
And so the language used is the this assumes phraseology, which clearly indicates a condition precedent. The language that was not used, but the appellant wishes was used, was language indicating that a reply email was sufficient to accept the offer made. Additionally, we know that the condition precedent of the hearing not going forward was a material term. We know that.
But you lose me, because then we have the next email goes, we have a deal provided the parties agree to and execute a written settlement agreement, which I will draft for your review. If we cannot work out a written settlement agreement, then my client reserves his right to put the hearing back. And then CIE's counsel responds, understood, right? So I don't know, the hearing thing becomes less important at that point, don't we?
Well, I would say you have a stacking that occurs at that point. You have
what?
a stacking of, you have two conditions precedent.
Mhm.
The hearing going forward can kill this deal.
Mhm.
And also, if you don't have an executed settlement agreement, you will also not have a deal.
What are the remaining material terms in the settlement agreement? You've got the price and the time of payment. What else?
Well, Your Honor, you have to have an offer and an acceptance. So
That I understand from basic contract
right.
law. My question is, in your settlement agreement, what are the remaining material terms?
Well, it's limitless, to tell you the truth, because we don't have a situation where the parties, at least, we don't have a situation where 200 state agreed to be bound. We have, and it's important to break down each step. We have the counteroffer that occurred at the time of the hearing email.
Yeah, but that was agreed to, right? Yeah, of course, we're going to take it off calendar.
That was agreed to in context. Yes, admittedly, the word deal was used, and if you stop the analysis there, it's problematic for our side. But it says deal provided we enter into a written settlement agreement.
Right. And my question to you is, in that written settlement agreement, what were the remaining material terms?
Well, so there would be the standard terms that you have already raised, such as choice of law. You could have a prevailing party clause. You could have confidentiality. But the point that I'm trying to make is, in responding, deal provided that we have a written executed settlement agreement. 200 state was reserving its right to take a second look at this deal. And well, it should have, because that response came on the heels of CIEE underscoring the importance of the hearing, its concern about the hearing. And the materiality is of that hearing to CIEE is shown in 4 ways. One, the parenthetical statement. CIEE admits that going forward is going to cost it additional attorney's fees. Secondly, there's the obvious importance of the real estate attachment hearing. That hearing exposes CIEE to the risk that an attachment issues, and therefore there's complications for its development project. Thirdly, there's the all bets are off email. I can't think of a more clear way to indicate that a term is material other than that language. And fourthly, we have to consider the situation where the facts different. In other words, if the hearing went forward and the attachment did not issue, we know it did issue from the docket that's in the record. If it did not issue, could 200 State then come back and say, I want to now enforce the deal for $245,000? I submit that the answer would be no. You went forward. We have additional attorney's fees. We have other problems that you've caused for us. It's not going to get the deal done at $245,000. We also have.
My guess is we took the case to decide the issue of present execution, not settlement. So you might want to address that.
Understood. It's our position that that doctrine should not apply in this case. And that's and the reasons are twofold. First, CIEE has a viable, albeit imperfect, remedy upon a post-trial appeal. And that's because of the right that is at issue in this case. The right that is at issue is the right to be free from liability beyond the purported settlement amount. If a judgment issues in the lower court in excess of that amount, upon a post-trial appeal, the appellant can seek to have the judgment reduced to $245,000. Now, if there was a covenant not to sue in this case, that would be an issue where the right to be free from litigation would clearly be before you.
But that's what I mean, that's a little bit odd, isn't it? I mean, settlement agreements, you can have a settlement agreement without a covenant not to sue. The whole point of a settlement agreement is the suit is over. So I'm not sure that gets you there. I mean, I'm bothered by the fact that if this were a full settlement, it would seem to meet the exact requirements of present execution. It's a collateral agreement, and it can't be vindicated otherwise. But the problem I have is that it just seems to sweep everything in that's premature. But then the appeals court cases seem to fit within this definition. Fecto, do you want to take a shot at distinguishing Fecto? And there are 2 or 3 appeals court cases which say these kinds of email things are enough.
Sure, none of those cases involve a condition precedent. You will not find a condition precedent in those email exchanges.
They all involve basically these kind of fluid deals where lawyers are sending back emails. And we say that's, at least the appeals court said that's good enough. Why isn't it good enough here? I mean, I don't find your condition precedent thing very persuasive, but I do find the fact that there isn't a deal in writing. I mean, by the way, do we have in the record did someone start drafting this settlement agreement? Is it in the record?
It's not in the record.
Okay, so there's nothing that we don't know if it's a 400-page real estate document or a 3-page. We don't know anything about it, right? What was contemplated? Justice Wendland's question. We have no idea how, because this is a complicated commercial lease, right?
That's true,
big
Your Honor.
lease. How much was this for every month? This lease?
Excuse me?
How much was this lease for every month?
That I can't recall, but I can tell you that in the complaint that we have in the record, approximately 1.2 million was sought in damages. And that was based on an acceleration of the remaining rent. So Your Honor, if I can, if I'm understanding your question or concern correctly, it is, what if we do have, what about the case where we do have a fully executed settlement agreement?
Yeah, say we have a 10-page document you guys did after the hearing gets canceled. You enter into this agreement, you all sign it, you're all happy, and then your client changes his mind and says, nothing doing, I'm breaking the deal. Even though it's fully executed and everything else, shouldn't present execution apply to that?
I would say no to that hypothetical. And the reason being is that there's no built-in limits on the rationale behind applying the present execution doctrine to that situation. And
Well, isn't the two-part test the limitation? It has a two-part test. It has to be collateral and it has to be impossible to vindicate. Isn't it fully met if we have a fully executed agreement?
At that point in time, if the right at issue is the right to be free from liability, my point would then be that same right can be invoked in other circumstances. And you would have, looking just alone at settlement agreements, you would have a multitude of cases because every case is the subject of settlement discussions, alleged agreements, and even executed agreements. But additionally, the rationale that the right to be free from litigation, if that's in and of itself sufficient to apply the present execution doctrine, then you have to consider other affirmative defenses. Res judicata has already been discussed. I will discuss that a little further and say there really is no practical difference between the res judicata defense and the defense of a settlement. The only difference, which I submit as a minor difference, is that one limit has been reached by a judicial decision, and in the other circumstance, a limit on liability has been reached by agreement of the parties. That causes one to think about other circumstances where limit has supposedly been capped by a party's conduct. What about waiver? What about lashes? What about motions to compel evidence, discovery on key evidence? The party bringing that appeal can also argue, based on the rules of discovery, I should have a right to end this litigation by not allowing this key evidence to be compelled, or the opposite.
But
I
that-
should have
all of
access
that's
to
not
this.
inextricably intertwined with the merits.
I'm sorry?
All of those examples are inextricably intertwined with the merits and the underlying litigation, as opposed to whether or not there's a separate and distinct settlement collateral to the merits.
I would respectfully disagree. I don't think that a discovery dispute would come before the jury or the judge, should it be a judge case. I also would ask the court to consider the fact that with equitable defenses such as lashes and waiver, it can be very well the case that those are bifurcated from the trial of the base controversy. So in those senses, they could be collateral, check all the boxes, and you would have yet even more appeals, putting aside just the settlement agreements, which this court has yet to say, this court has yet to say that the right to be free from litigation in it of itself is enough. It has always had statutory, that right being statutorily granted before it. I would briefly like to address some arguments that the appellant has made. The appellant has argued that we have waived the right to bring the second condition precedent, and by that I mean the lack of a written executed settlement agreement. When the court looks at the lower court papers, they'll see that issue was addressed by both parties. In fact, the appellant dedicated an entire argument section to that issue. And indeed, the court recognized that, and that's why the court expressly found that a settlement agreement was not signed. So the court not only endorsed the first condition precedent as a reason a deal was not made here, but it also implicitly endorsed the second. There was no signed agreement. The doctrine of prevention is actually one that really was not raised in the lower court papers. Nonetheless, that doctrine clearly does not apply here. That doctrine, if you look at the Gables case and other cited authorities, applies to an already formed contract. It does not serve to bind a party to, it does not serve to show acceptance. Stated another way, parties are always free to walk away from settlement discussions, to break them off at any time short of a deal. And that's exactly what we have here, I would suggest to the court. We have a situation where an offer was rejected by going forward with a hearing after settlement talks broke down short of an executed written settlement agreement.
Okay, Attorney Lucio, I see your time has expired, and so I'm going to say thank you.
Thank you.